Well, the Supreme Court ruling unanimously today against the NCAA strict limits on student aid and compensating college athletes after years of court battles. The High Court says the NCAA violated antitrust laws by limiting the student funding. And the decision comes as college athletic departments still struggle with the issue on how to preserve its amateur status. But some say today's ruling could have some broad consequences for the future of college sports. Joining us now to discuss is distinguished university professor at Touro College and author of Saving Free Speech, Thane Rosenbaum. Thane, thank you very much for joining us. We appreciate it.
Anytime, Heather.
So this only covers part of the issue. It does not include paying a salary of sorts to college athletes. It lifts this limit on monies that they could get for tuition or books, things like that. I think there was a $5,000 limit.
Right, Heather. I mean, the basic principles, the antitrust laws prohibit price fixing. And if you're a big-time college athlete, you can't negotiate with your university how much you get to receive by coming to them. Every player gets the same thing: tuition, room, and board. That's what all throughout NCAA, that's the rule. So the Supreme Court's position today was, well, if you're limiting it only to educational benefits, why can't they include other educational benefits like computers or tutoring, or if you're a music student, a saxophone, paid internships, study abroad, and my personal favorite is graduate school, right? What if you're really smart in high school and they come to recruit you and your parents say, yeah, but he or she's really smart, will you pick up law school after or medical school after? Up until today, that was not permitted. You only get when you're playing, not after you're playing. So they've just basically expanded the list of what are educational benefits, but they haven't gone as far as what you're saying before, Heather, salaries.
But what was interesting is the way I was reading the opinion is they left that door open, because the lower case that came to them was only asking them to rule on this particular segment of the question. But I forget who wrote the, was it Kavanaugh that wrote the majority?
It is Kavanaugh.
He wrote the majority opinion and essentially said, we're not deciding whether students should be able to negotiate for pay. We're leaving that aside. So does that mean they're open to fielding that?
Well, Bob, I tell you what's going to happen next week. There's already a congressional measure that has gotten some energy, but after today, for sure, I think even the NCAA is going to step in to say, well, what about what's called names, images, and likeness, right? Universities make lots of money off of the names, images, and likenesses of players for endorsements, video games, a hat, a jersey, a mug.
But Thane, that's a subset. I mean, there's only so many guys, male or female, that are going to get their names in an electronic game or a video game. What about the pay for playing football or basketball?
It's a good question. But look, Bob, here's what the NCAA has always said, and you tell me what you think. They say, we benefit consumer welfare by not paying the students, that the fans like to know the NFL gets paid and the college athletes do not. I don't know anyone that's ever said that, but that's what the NCAA keeps saying, that it's our job to preserve amateurism. So what you're describing is it's off. There is no amateurism, that every player, every student can negotiate their own deal before and taking as part of their scholarship. Then, of course, that means that there's, as Kavanaugh has suggested, there's no exemption from the antitrust laws. The NCAA cannot function like a monopoly, which is what it is right now. The next step is, we're not there yet, but the question is, will the court say amateurism is meaningless if you're making what you're making, tens of millions of dollars? I'll tell you what the court was interested in the oral argument. They heard that strength coaches make $500,000 a year, not the head coach, the strength coach. And they said, this is just ridiculous.
Yeah. I mean, it just seems a little bit backwards, because we know that these universities are making tremendous amounts of money off of some of these student athletes, but in their effort to preserve amateurism, they're not allowing these students to get paid what they're worth.
Yeah, I went to college on a baseball scholarship, so I know guys that were on scholarship, football, basketball. So I think they should be able to get more money than they do. But I'm not sure it should be, what the market will bear.
But Bob, let me ask you a question on that baseball team. Did everyone graduate? Because the Supreme Court basically said that student athletes have very low graduation rates, especially in major sports.
Some colleges, some sports. I think they should be obligated to pay for you to graduate and provide tutors to help you do so. I think you should get medical benefits beyond your college career.
What about disability insurance? That's
exactly,
another thought.
that sort of thing.
Well, that's what today's ruling would go toward?
Yes,
Some of those
you
ideas.
could make it.
Okay.
You could make an argument, Bob and Heather, that disability insurance now is an educational-related expense. But the question is, will they cap it? Right.
Yeah.
So let's say you have courses off campus. Theoretically, after today, they could buy you a car. Right. It's educational-related benefit, but I have a feeling they're going to cap some of it.
Yeah, it'll be an interesting conversation. That's why we wanted to have you on, Thane. Thank you.
Thank you both.
Thanks.